Good morning everybody. Today we'll discuss land loss and we'll discuss about the first unit. So here the first unit, that is consists of right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. So as you all know that there is many public purposes by the government, that is by the appropriate government, and the appropriate government, either it may be central government or it may be a state government. They need property for certain development projects. So we all know that government owns many property, and in that property they make many constructions and other things for the development of the nation. And where the government needs more property than what they are having in the name of government, then in that time they are acquiring the property from the public, that is the private owners of the properties, for certain projects in certain areas. So while acquiring the land, what is the procedures has to be followed and how it has to be acquired, and what is the compensation given to the public, and what is the rehabilitation and resettlement. These things are the part of the first unit of land loss, and today we are going to discuss about these things. So again, it is an act of 2013. This is the central act. So we'll go according to the sections. Here as usual, the section 1, short title, extent and commencement, that is mentioned in section 1 to 3. Here section 1 speaks about short title, extent and commencement. Here the short title is land loss, and it extends to the whole of India, and it commenced in the year of 2013, where it is published in the Government Gazette notification. That is the day of commencement of the act. This is the 3 sections of the first unit, that is short title, land loss, and extend to the whole of India, and commencement from 2013. So here, as I told, this property will be acquired by the government from the private persons. So here, preparation of social impact assessment study, this is mentioned under section 4. Here the preparation of social impact assessment study means before going to do or commence of a project, they want to get the social impact on that particular project, and they want to make an assessment on the project. For this, the appropriate government, that is the central government or the state government, as the case may be, they'll give a notification to the particular part or the particular state regarding that particular project, like panchayat, municipality or municipal corporation, as the case may be. If the project is going to be done in a particular village or particular panchayat system, in that particular area the notification will be given. If it is in the municipality area, then the notification will be given to the particular municipality, or if it is in the municipal corporation, then this notification will be given to the municipal corporation, as I told, as the case may be, as the project is for that particular place, either in village level or in district level or in urban places. So the particular notification will be given to the particular place. So here after giving the notification to the particular place, a period of within 6 months the project has to be commenced. So within that time they have to make the assessment. To making this assessment, they will make an committee or a team by the government, and they will do the field work in the particular area. While doing the social impact assessment, they have to follow many things in that particular areas to make the assessment. So here the first thing is, so the assessment as to whether the proposed acquisition serves public purpose. Means the first thing is that they have to make an assessment with the public, that what is the public opinion about that particular project or the purpose which is going to be done by the government. So whether it is purely public purpose, that has to be considered, and public opinion should be taken on this regard. The next thing, estimation of affected families and the number of families among them likely to be displaced. So here in that particular area, whether it is a agricultural land or it is a residential area or is an industrial area, like that there are different types of land. So here whatever the land which is selected for that particular project, they have to make an assessment that which is the nature of that land, what is agricultural land or a residential land or any other kind of land. If there is the families living or residing in that particular place, then they have to make a list of numbers of family living in that place and how many families or number of families has to be displaced from that place to another place. That is supposed to be listed by the committee. And the next thing is that extent of lands, public, private, houses, settlements and other common properties likely to be affected by the proposed acquisition. The next thing is that it's not only a private property, even in that particular area government property will be there, as well as private property and private houses and any other common properties which may be there. So they have to make a list of all different kinds of property and the survey numbers of that property which comes under that project for the acquisition of property. The next thing, whether the extent of land proposed for acquisition is the absolute bare minimum extent needed for the project. And the next thing is that it's not just like that they can acquire the land whatever or how much extent they can do. It's not like that. The minimum needed extent of property that has to be acquired. For that they have to make a survey that what is the minimum area which they are required to make the project. So by that, what are the extent of your particular existing building or any other construction. They may not take the whole building or the whole property. They may take part of that property which is required for the particular project. So means here the limited extension of the property should be acquired according to the map or the plan which is approved by the government. According to that only they have to make the acquisition. The next thing, whether land acquisition at an alternate place has been considered and found not feasible. So while acquiring the land, the committee has to be find an alternative place for the people to move from this place to that place. If it is found, and that has to be considered by the committee that whether it is a good place or it is feasible for the public or not feasible for the public. So based on that they have to decide whether the people should be moved to that place or they have to make any other arrangements. After this study of social impact of the project and the nature and cost of addressing them, the impact of these costs on the overall cost of the project. So whatever the land acquiring by the government for the particular project and the cost, how much it is necessary for acquiring the lands, and what is the cost of the whole project, and if they do that project, what is the benefit from the project. These things should be considered by the committee. If the project cost is more and land acquiring cost is more, and after this the benefit is very less than the expenditure, or the benefit is not so much, or it's not so good for the public, then it can be considered as investing of so much of money into that particular project is whether useful or no. So like that they have to make an assessment regarding this. And while making the social impact assessment, study under subsection 1 of section 5, they have to check that the livelihood of affected families, public and community properties, assets and infrastructure, particularly roads, public transport, drainage, sanitation, source of drinking water, source of water for cattle, community ponds, grazing land, plantations, public utilities, and such as post office, fair price shops, food storage godowns, electricity supply, healthcare facilities, schools and educational or training facilities, Anganwadis, children parks, place of worship, and land for traditional tribal institution and burial and cremation ground. So these much of facilities should be there where they are going to rehabilitate the particular family which is displaced from the place. And again, the appropriate government shall require the authority conducting the social impact assessment study to prepare the social impact management, like plan, listing and measures required to undertaken for the particular plan. So these are the things which is supposed to be done while the social impact and assessment is done by the committee. So this is very important. And then this special provisions to safeguard food security under section 10. So here when they are acquiring the land for that particular project, if the land is an agricultural land and where it is grown food grains and other crops in that particular place, then they have to think. Then they have to think means they have to safeguard the food and security. So here it is mentioned in section 10 that there should be no irrigated multi-cropped land shall be acquired under this act. If there is a land which is multi-cropped land, then they should not acquire the land for such kind of projects. But under certain circumstances, these property also can be acquired by the government. Like for example, such land may be acquired subject to the conditions that it is being done under exceptional circumstances as a demonstrable last resort. So here in that particular project there is no other way or there is no other chances of getting other land, or this agricultural land that is multi-crop land comes in between the project or proposed project plan, then there is no other chances. So the acres of land, that agricultural land is very lesser than the project land, then it has to be acquired. There is no other chances. For the small piece of land, they cannot change the project to some other place, and if the project is done with the particular place, the particular place development and other benefits will be given to the public. So for such kind or for the public development, they have to acquire the land. There is no other choice or chance. So the next thing here, whenever multi-crop irrigated land is acquired under subsection 2 of section 10, an equivalent area of culturable wasteland shall be developed and agricultural purposes for an amount equivalent to the value of land acquired shall be deposited with the appropriate government for investment in agricultural for enhancing food security. If so, such land is acquired by the project, then whatever the alternative wasteland which is available in the other place or nearby that particular project plan, so that land should be converted into agricultural land, and for that what is the cost is required, that should be deposited with the government for investment in that particular area for enhancing the food supply and food security in that particular land, and the waste land should be converted into agricultural land by the government. And the other thing is that if the case is falling within the district or state, then the state government or the particular district collector has to be given the notification for the purpose. So here notification and acquisition of land. So here section 11 speaks about publication of preliminary notification and power of officers thereupon. So here the appropriate government, when they are proposed to be the particular project in that particular place, that has to be published in official gazette. After publishing in official gazette, that particular project should be published in 2 daily newspapers that is circulating in the particular locality of such area, whether it may be a village or district or the state. It should be published in 2 daily circulated newspaper in that particular local areas, and the one newspaper should be in the regional language. Then in the local language, in the panchayat, municipality or municipal corporation, as the case may be, and in the officers of the district collectors, the subdivisional magistrate or the tahsildar, as the case may be. So it has to be published in the name of the district collectors or the subdivisional magistrate or the tahsildar, as the case may be in that particular area or particular location. So that should be published in 2 newspapers, and one is in the local language and the other one is the general English newspaper. The next thing is that upload on the website of the appropriate government. The appropriate government has to be update the details of the project, plans and the survey numbers of the properties which is going to be acquired, name of the owner and the extent of the property. The whole detail of the particular property should be mentioned in that particular notification. So while uploading in the government website, they have to clearly mention the gazette notification date and the list of the properties which is going to be acquired and what is the purpose of the project, the name of the project, then the list of the properties like serial number, survey number of the property, then extent of the property, then owner's name. So all the details should be mentioned in the website. Even the public can visit the government official website to know more about the acquisition. So this is the things considered as giving notification to the public. So here the notification will not be sent individually to each and every person who is holding the land under the particular project where the property is listed. So when it is published in the newspapers, after publishing in the official gazette and where it is uploaded in the website, then it is considered that the notification is given to each and every individual who is holding the property that falls within the project place. So here no need of giving an individual notification to each and every person. It is considered that if it is published in the newspaper, it is the notice is given to all the people of that particular area. So here so the government, that is by the collector, they have to declare and they have to update the land records and prescribed things within 2 months of the gazette notification. So that has to be published in the newspaper or in the website. So it is the duty of the collectors to make a list and collect the details of that particular property, and which has to be updated in a prescribed manner in the website. Then section 12, that is speaks about preliminary survey of land and power of officers to carry out survey. Wherever the preliminary survey has to be done by the committee, where the government has appointed certain persons or group of people for the particular project, and they are considered as the survey officers of that particular project, they got certain power to carry over the survey and other works relating to the project. So here the person is doing the work on behalf of the government, so they got certain power, or the power is given to the person by the government. Just like the person can enter upon and survey and take levels and of any land in such locality. So no person shall stop the government officer who comes to do the survey in that particular place or under the particular project. So here he can enter any place, and he can even level the place, and he can make any changes into the land. He got the power to do so. That is the power given for the preliminary survey. And the person got the power to dig or bore into the subsoil. So it may be whatever the nature of land, that it may be agricultural land, maybe the trees or plants even standing. When it is approved and it is comes under the project, so they have to enter the place and they have to dig the earth or bore the earth, or they have to check the subsoil, as you may be seen in many places. Even you may be seen in this metro construction and other highway projects. They'll dig the place, dig the earth to get the strength or the thing of subsoil. So like that here also they can do, they can dig, they can bore, and they can test the subsoil in the place or the land which is come under the particular project place. Then to do all other acts necessary to ascertain whether the land is adopted from such purposes. So here what are the necessary thing which has to be adopted and which has to be done in that particular place, the officers can do. They can make certain conversions, they can do certain other necessary works in that particular place to make the project, that is the preliminary survey of that particular places. Then to set out the boundaries of the land proposed to be taken and the intended line of work proposed to be made thereupon. So when the property is acquired for the purpose of any particular project or is going to be acquired, so the officers, while doing the preliminary survey, they make the boundaries or they set the boundaries of that particular land. So here imagine that a person is holding like 50 acres of land. Another 50 acres of land, the government needs only 10 acres of land for the particular project, or the 10 acres land falls in that particular lane of the project. So the government will acquire only the 10 acres of land. While making the preliminary survey, these officers will make a boundaries to the particular 10 acres of land. The remaining 40 acres will be left with the person. While doing so, they maybe put a stone in the 10 acres to mark that this is comes under the project lane, or they make any temporary boundaries for that, like fencing or making stones or some other things which is required or which is possible to do on that such place, like that they can create a boundaries showing that this is the property, only the extent of property is acquired for the purpose of that particular project. They may be keep certain signboards to show that this is the project land, and they may put some signboards that trespassers will be prosecuted, or this is the land belongs to that particular project, like that signboards will be kept within the boundaries or at the end of the boundaries, like that they can set the boundaries of that particular property or the line of the work. Then to make such levels, boundaries and line by placing marks and cutting trenches, and where otherwise the survey cannot be completed, and the level of the boundaries and line marked cut down is part of any standing crop, fence or jungle. So while doing this, the boundaries has to be finalized, otherwise the project work will not be started. While doing the preliminary survey, the land has to be leveled. Land has to be leveled means it may be a residential houses there, they have to pull down the house, then that has to be done like a plain land. Or imagine a standing crop or timber or plants are there, it is agricultural land, then the thing should be cut down, the crop should be cut down and it should be made it as a plain land. Even if it is a jungle or a forest property, a certain extent of property comes under the line, then that property, that forest property should be cleared like plain, like by cutting the trees and making if there is a rocks or some stones that has to be removed, then it has to be make it as a plain land to make such to do the project. So this is the preliminary work, like they are making all the things which is there is a residential house or trees or timbers or any other rocks or stones, whatever it is. So they have to cut down and they have to, if it is a stone, they have to break the stone, then they have to make it a plain land and they have to set the boundaries both the sides of the property. Then they have to keep a signboard that this properties belongs to the particular project. This is the preliminary survey of land. So after this, section 13, that is that speaks about payment for damages. So while acquiring the land, we are acquired like the agricultural land or any other land, residential building or even forest property. So such thing, whomever belongs to that particular property, they are supposed to get the payment in the way of compensation or as a damages. So for this, the collector, the district collector or the appropriate officer for that particular project has to make a list of the owners of the property, and according to that the compensation or damage has to be paid to the person in monetary way. So this is the work of the chief revenue officer or the district collectors or the district revenue officers, and the district revenue officer's decision will be final while making the compensation according to section 13. Section 14, that is the lapse of social impact assessment report. So this report has to be done within 12 months from the date of appraisal of the social impact. If there is any lapse into the social impact, then little more time to be extended for the particular thing, and they have to make the assessment complete within the prescribed time. Then that has to be submitted to the appropriate government. And while submitting the report to the government, along with that they have to upload the particular thing in the website of the government authority. Next, section 15 speaks about hearing of objection. Here under the hearing of objection, where the owners of the land or the owners of the particular property, if they have any objections for acquiring the land or in the terms of monetary, that is the damages or the compensation, or any other objection, like if such project is done in that particular area, it may spoil the underground water or drinking water, or the locality atmosphere may be spoiled, like that. If they have any objections regarding that project, then that objection has to be given within 60 days from the date of publication of the preliminary notification. So here, while making the objection, they have to observe three things, or they have to consider three things. The first one, the area and suitability of the land proposed to be acquired. The second thing, justification offered for public purpose. And the third thing, the findings of the social impact assessment report. So these three things has to be considered. The first one is that the area and suitability of land proposed to be acquired. So here the land which is selected by the committee for the particular project, they think that that is a suitable land for such particular project. So that's why they selected that particular place. So for that, if they have any objection, they have to file the objection. That they may tell, the people may tell that this is not the suitable to the place or the particular project, like that. Then the justification offered for public purpose, and the particular project is done in that particular area. It is the development of that particular area, and the purpose is only for the particular people in that particular locality or the neighborhood or the nearby locality people. So that has to be considered. The people has to think that, and not only thinking, even they have to understand that this is done only for the benefit of ourselves. The next thing is that the findings of the social impact assessment report. So before doing this particular project, there is a social impact and assessment is done by the government with the experts, that has to be analyzed by the owners of the land. Then after analyzing all the 3 points, they have to make an objection if they have so. So that objection has to be raised within 60 days from the date of publication of the preliminary notification. So section 16 speaks about preparation of rehabilitation and resettlement scheme by the administrator. So here, after making the preliminary inquiry and preliminary survey of that particular place, now the next stage of the project is preparation of rehabilitation and resettlement scheme by the administrator. Means they have to prepare the rehabilitation and resettlement to the owners of the property. So this has to be done by the district collector of that particular area. He shall be the administrator for the rehabilitation and resettlement, and shall conduct the survey and undertake a census of the affected family. So he has to do the census in that particular place where the number of people who lost the property, either it may be a land or it may be a residential property. And they, while making the census, they have to follow few things, and they have to collect certain details regarding the family, like that. The first thing is that particulars of land and immovable property being acquired for the each affected family. So they have to make a list that the particular of land, that is the survey number, extent of land which is acquired, and the immovable properties, whether it is a land or it is a residential building. So that is acquired, and the number of families and the owners details should be listed by the collectors. The next thing, livelihood lost in respect of lands, losses, and landless whose livelihoods are primarily depending on the lands being acquired. So here means the person who is holding the land, either agricultural land or any other kind of land, who lost the livelihood from that place, and the other people who doesn't own the land but based on this land their livelihood also lost. Means they are doing either they may be doing work in that particular field as a coolie workers, or they are grazing their cattle in that particular place, or related things. The other than the owners of the land, the people who lost their livelihood from the particular land, that list also made by the collectors. So like here it comes again two lists. One is the owner of the land who is lost the land. The second thing is the person who doesn't own a land or property in that particular place, but his livelihood is lost. I imagine that I'll give an example that in a particular place a residential building was there. Along with the residential building there is certain shops in that particular building itself. So the owner lost the property, and the tenant, the person who's holding the shop, is making a business or any petty shop in that particular building, he also lost the livelihood. So this person's that business, what kind of business is done and from how many years is done, and he is invested anything in the building for the particular shop renovation, all those things has to be considered. So like that they have to make a two list. One is the owner of the property, the second one is who lost the livelihood from that particular property. Then a list of public utilities and government buildings which are affected or likely to be affected where resettlement of affected families is involved. While the next thing is that the public utilities or government buildings within the project plan, the government building may comes or public utilities building may come. So this public utility building may be a government building or may not be a government building, but it is a public utility building. Imagine that a library is there under that particular listed property. So by demolishing the building, the library, it is lost for many people. Or a sports ground is there, or any supermarket or any shops, like that public utility place, and along with the government properties. If there is any government building which comes under that particular plan or particular project, that has to be demolished or that has to be taken for that particular project, that has to be again one more list has to be done. It is the first list is that government buildings which is going to be demolished or used for that particular project. The second thing is that the list of public utilities buildings or places when it is used for this particular project, the people who utilize that particular property for certain purposes, they are the losers for the particular thing. So that list has to be done, and which are the families affected by these buildings, that is to be listed by the collector. The next thing, details of the amenities and infrastructural facilities which are affected or likely to be affected where settlement of affected families is involved. So the infrastructural facilities and amenities which is there in that particular place, that is also has to be listed, that like which are the families or how many families are affected with this resettlement or rehabilitation has to be done to the family. Then the next thing is that details of any common property resource being acquired. Details of any common property resource acquired means where the owner is more than one person, or a joint family property, or any property which belongs to like partners or any other association like that, where the owners are more than one and they have to make a separate list for such kind of properties. So this has to be done by the government, while based on all these things they have to fix the compensation or even resettlement by providing such other land to the people. Section 17 speaks about a review of the rehabilitation and resettlement schemes. So once this list is made by the collectors, and that has to be submitted to the government, and before submitting to the government, the collector shall review the draft scheme submitted once again. So then after reviewing this, they have to subject to be submitted to the government authority, that is appropriate government authority. Then after considering this review draft, finally it has to be submitted by the collector to the Commissioner of Rehabilitation and Resettlement for the final approval for the scheme. Section 8 speaks about approved rehabilitation and resettlement scheme to be made public. So once this rehabilitation and resettlement scheme is approved by the appropriate authority, then that has to be uploaded in the government website, and it has to be given a notification to the public where the amount of compensation or damages, or even when the government is ready to give alternative property to that particular person, all the details should be published in the official gazette. Based on that, it is given to the public notification. Next, section 19, that is speaks about publication of declaration and summary of rehabilitation resettlement. So here, once the project is approved by the appropriate authority, then that has to be the summary of the rehabilitation and resettlement, that has to be published in the official gazette, and that has to be uploaded in the website, and along with that it has to be published in the daily 2 newspapers circulated in that particular place, and one should be in the regional language, and the notification should be given to the panchayat and municipality and the municipal corporation or the collector of that particular place who is supposed to be held by the thing. Then that has to be uploaded in the official appropriate official website as the case may be prescribed. So here the district or the territorial division in which the land situates. So these things should be published in that particular district or the territorial division in which the land is going to be acquired. Section 20 speaks about land to be marked out, measured and planned, including marking. So after the land is acquired by the authority, they have to mark the land and have to measure the land. After measuring according to the plan, they have to make specific marks on the land, like that has to be digged, or that has to be bored, or the soil test has to be done. According to that, the specific marks should be made on that particular land. So here section 21 speaks about notice to the person interested. So here, while acquiring the land, the collector shall publish the public notice in the website. That notice is given to the persons, or the person who's owner or who's holding the property. So the compensation, the amount of compensation and the plan and every detail has to be given to the person, interested person, either in the website and also in the other medium of notification to the particular person. So the public will come to know about the notice, and within the 6 months they have to approach the authority. Section 22 speaks about power to require and enforce the making of settled statements as to the names of interest. So here the collector of the particular place, the district collectors or the sub collectors, has to make the details of the person, the name and other details like property and survey number and extent of property, all those things, that has to be prepared within 30 days of the from the date of requisition given to them, and if the property is mortgaged or any tenant is there or any other interested person to that particular property, that has to be list has to be made by the collector. Section 23 speaks about inquiry and land acquisition award by collector. So here the one day will fixed by the collector on the day. If any person is having an inquiry or they have a discussion with the collector, the people can come before the collector and discuss with the collector on that particular day with their grievances, like they may demand for the higher rate for the particular land or etc. That the negotiation has to be done with the collector within the fixed date. The aggrieved persons or the owners of the land and other people who is interested in the land can come before the collector on that particular day which is fixed by the collector, and they can discuss and they can do resettlement. And after taking opinions from the gathering of the owners or the person who is having the interest in the property, the collector will be takes a decision based on the opinion of the public, and they will record all the things, the opinion which is given by the public also for the further purposes and any other inquiry if it arises in the future or arises in the future. Section 25 speaks about period within which an award shall be made. So here within the 12 months from the date of publication of the declaration done under section 19 by the collectors, that is in the notification, so they have to settle the amount to the people or the interested person in the property without any lapse. And according to section 26, determination of market value of land by the collector. So here the market value of the land has to be considered by the collector while acquiring the land and while the inquiry discussion is before the interested persons or the owners of the property. As you all know that this market value is mentioned in the Indian Stamp Act 1899. So according to that, while the property is registered or property registration has happened in respect of any sale or any other purchase in that particular area, the value will be mentioned in the act. So according to that, the market value should be considered, and the similar value which is there in that particular locality, even that should be considered, and whichever is the highest price comes, that has to be fixed by the collector for the aggrieved persons. And if even the persons also agree with the percentage of the person, then that should be made as final for the particular property's value. Section 27 speaks about determination of amount of compensation. Here the collector having the determination of the market value, and according to the land acquired shall be calculated the total amount of compensation that has to be paid to the landowner. So section 28 speaks about parameters to be considered by collectors in determination of award. While the collector making the award, he has to determine few things that is mentioned as point wise. The first thing has to mention that the market value as determined under section 26 and the award amount in accordance with the first and second schedule. So while computing the award to the person by the collector, that is the owner of the property, so they have to consider the market value of the property in that particular place. According to that, the amount has to be calculated by the collector. The second one is that the damage sustained by the person interested by reason of the taking of any standing crops and trees which may be on the land at the time of the collector's taking possession. Therefore, here the property stands in the name of owner, and the person who cultivated the property is different. While taking the property by the collector, here the person who cultivated the land also got the interest into the standing crops and timbers in that particular land. So here both the persons got the interest into the property. So the collector has to determine both the interest, that is owner of the property has to be get the compensation for the property, that is for the land, and the person who's cultivated in the agricultural land, and he also got the interest regarding the standing timber and crops, so he also get the compensation for the particular crops and standing trim. So here both the persons who's affected by the acquisition of that particular property should be considered while making the award by the collector. Then the damage sustained by person interested at the time of the collector's taking possession of the land by reason of severing such land from his other land. Even the other persons who is having interest over the land, that has to be considered by the collector while making the award. He has to take a note of the person in what way he is interested in that particular land. Then the damage sustained by the person interested at the time of the collector's taking possession of the land by reason the acquisition injuriously affecting his other property, movable or immovable, in any other manner, or his earnings. So the next thing is that while the property is acquired by the collector for the particular project, the other person who suffered either movable or immovable property because of this acquiring, even that has to be notified by the collector, and even that person should get certain compensation for that. For example, here imagine a residential building is there and the whole residential building has to be taken for the project. So while acquiring the land, that particular land which is having a building, so when they pull down the building, the nearby or the adjoining building also got certain damages or injurious to that particular building. A portion of that particular building also damaged while acquiring this land. So even that owner got interest into the damaged portion of that particular property which belongs to the person, the neighbor. So even for the damage happened because of the acquisition, so that person also got the interest into the award. So the collector has to make a note of that, and what is the portion or part of the building is damaged, for that also the award has to be compensated by the collector. Next, in consequence of the acquisition of the land by the collectors, the person interested is compelled to change his residence or place of business or reasonable expenses incidental to the such charges. So apart from this, if the collector is directed to the person who is interested in the place, and if he directs that person to change his place from that place to another place, or is compelling that person to change his place because there may be severe damages may happen while doing the acquiring and other project works. So when he is compelling other person to change his place from that place to another place, then the reasonable expenses for changing his residence or other business from that place to another place, that cost also given by the collector to the person, and that has to be considered by the person. The last one, any other ground which may be interest of equity, justice and beneficial of the affected families. Along with this, if any other things which is supposed to be done with the family, that has to be considered in the interest of equity, justice and beneficial to the affected family by the collector. The next section 29 speaks about determination of value of things attached to land or building. So here, while awarding the while awarding the compensation to the building, even the collector has to be considered the value of the things which is attached to the land or building. So here if it is not a plain land, even if in a plain land there are certain things which is attached to the land, that also considered as valuable thing, and that has to be considered. Along with the land, even the building also, the attachments to the building and the valuable things which is there in the building, that value also should be considered by the collector. For example, if a building is there which is constructed with a single floored building without any valuable things, only for that particular construction, this collector has to be given a award. But the next building in the same place where they used this marbles and costly granites in the house, and there are many valuable things attached to the building and that cannot be separated from the building, while demolishing such kind of building, the fittings, costly or valuable fittings which is there in the building, that has to be considered, and the amount fixed for these things also while making the award. Section 30 speaks about award of solatium. Award of solatium means the additional allowances which can be given along with the compensation, that has to be given by the collector, like that the overall loss for the person apart from the land or building or any other thing, the reasonable loss which has to be happen to the person, that has to be compensated by the collector to the particular owner of the property. Next, section 31 speaks about rehabilitation and resettlement award for affected families by the collector. So here the rehabilitation resettlement has to be done by the collector for the affected families. They have to follow few things, that is rehabilitation and resettlement amount payable to the family. So the rehabilitation resettlement, what is the amount cost for their livelihood, property or land which is lost, for that the amount has to be paid to the family by the collector. Then while doing so, the bank account member of the person to which the rehabilitation and resettlement award amount is to be transferred. They have to get the bank details of the particular member of the family, then the amount should be transferred to that particular amount to the particular person. Then particulars of house site and house to be allotted in case of displacement of families. In one thing that they are going to pay the amount to the family for the land. The second thing is that instead of paying the amount, they may give the land in some other place. Alternative land will be provided to such person. When they provide the alternative place, this family has to displace to that particular place. While transferring all the goods and other things, the cost of the transfer has to be paid by the collector. Then particulars of land allotted to the displaced family. The details of the particular families and that properties, alternative land is given, that has to be made a list and that should be provided to the people. Then particulars of one-time subsistence allowance and transportation allowance in case of displacement of family. While displacing the family from one place to another place, the one-time transport charges has to be paid by the collector to the particular family. Then particulars of payment for cattle shed and petty shops. If in the previous land where they have the petty shops and cattle shed, and if they are going to replace this land, then even for that shed and for petty shops, the amount has to be given by the collector to the particular family. Then one-time amount should be given to the artisans and small traders while shifting from under the displacement one place to another place. The one-time amount should be given for them also. Then section 32 speaks about provisions of infrastructural amenities in resettlement area. So as the resettlement area is fixed by the collector and that is provided to the particular family which is affected by the acquisition. So the basic minimum amenities should be provided by the collector as per the third schedule, which is mentioned in the third schedule. According to that, the basic necessities should be fulfilled in the displacement area. Then that place should be provided to the displaced owners of the land who lost the lands in the acquisition. Then section 33 speaks about corrections of awards by the collectors. So here, once the award is made, not later than 6 months, if there is any corrections has to be done by the collector according to the reference under section 64, making any changes into the interest or into the award, you can make certain changes with the existing award, and after making that corrections in the award, the notification should be given to the particular person who is interested in that particular property that there is certain changes made into the award. So that notification should be given to the person regarding the corrections. Then according to section 34, adjournment of any enquiry. Here when there is an enquiry before the collector by the person regarding any dispute related to the acquisition land, so such dispute or enquiry may be adjourned by the collector to the next date. So here the person cannot force the collector to decide the same date as on. So the collector got the right to adjourn the enquiry. And according to section 35, the collector got the power to make and enforce attendance of a witness. He can provide the summons to the person and he can ask the person to provide the documents before him to make an enquiry into the existing property according to the CPC, that is Civil Procedure Code 1908. So he can give the summons and he can call for the witnesses to come before and give evidence, and even he can ask the person to produce the document which is required or related to that particular dispute. Then according to section 36, power to call for records, etc. Here the appropriate government, that is either the state government or the central government, if they think so, according to section 30, they can call for the record of the particular dispute and they can look into the matter and they can give the direction to the authority as it may thinks fit. Section 37 speaks about awards of collectors when to be final. So here when the collector fix the award to the particular property, and after that if they make any enquiry into the land and even if the owner is not satisfied with the particular award, so after this enquiry or discussion with the collector, according to the value of the land in that particular place, the market value will be considered, and along with the market value, the solatium, that is the solatium means that the relating additional allowance to the particular property also added to the loss to the person. So the overall amount will be fixed by the collector and that become the compensation amount or finalized by the collector. And section 38 speaks about power to take possession of land to be acquired. So once the preliminary notification is published in the official gazette, and when the collector can take the possession of the land, so while making the compensation and making the payment of compensation to the owners of the person or rehabilitation resettlement entities are paid, and within a period of 3 months after fulfilling all those needs, within a period of 3 months the collector can take the possession of the property. Section 39 speaks about additional compensation in case of multiple displacement. As I told earlier, if the displacement is done from one place to another place, one time amount for the transportation and related things has to be paid to the person. If it is done multiple replacement from one place to one place, again from that place to another place, if they are moving the person, then the cost for the additional or multiple displacement has to be paid by the collector to the aggrieved persons. Next, section 40 speaks about special powers in case of urgency and acquire land in certain cases. So here what we discussed, that is the normal procedure that is done while acquiring the land, but in certain special powers or in some emergency requirement, these general provisions will not be followed, and some special powers will be used under such circumstances. So here, that is, the collector can make notification of the thing of that particular property which is directed by the appropriate government. So the government will having the absolute power to take the property within the 30 days through the collectors, and the property should be free from all kinds of encumbrances. Like the special powers or urgency will be in defense of for the purpose of defense or national security or any emergency arising natural calamities or any other emergency within the approval of Parliament. So they can take the property and they can use the property for that particular things. And apart from this, the collector shall not take possession of any building or part of building under the subsection without giving to the occupier, therefore, at least 48 hours notice of his intention to do so. So at least a minimum 48 hours notification has to be given to the owner, then the property can be taken or possessed for the particular thing. And before making a possession of the property, the compensation has to be paid to the particular person. So this is the overall thing relating to the right to fair compensation to the person. Here in short conclusion, we can tell that where the government needs certain property for a particular project or development for the particular area, so the government is going to acquire the land from the private persons, and they will make a plan, and according to that, what are the extent of property required, the government constitute a committee, then the committee will make the preliminary survey in that particular place. After making the public notification in the Gazette notification, then in 2 daily newspapers circulating in that particular area will be published, and one will be the regional language. Then the objections will be heard by the collectors of the local people, and that objection, whatever the objection raised by the public also considered. Then based on that, the assessment report will be given to the government, that appropriate government. If the appropriate government is ready to do the project in that particular place, then after paying the compensation to the particular families, the government can acquire the land and they can start the project in that particular land. Here, like the owner will be having interest in the property, so they will get the compensation. But apart from the owner, the person who is having interest in the place, because of that his livelihood lost, even he also got the interest in that particular property, so he also paid compensation for the livelihood. And in the resettlement, if there are rehabilitation resettlement is doing for that particular property, if the person is transferred from one place to another place for the displacement, then the one-time cost should be paid. If the person is more time displaced from that place, for that more compensation has to be given for the multiple displacement. And the other necessary things which is supposed to be given as solatium to the people, the government has to give and satisfy all the required things to the public. So here it is the government primary duty to make compensation to the public, and all the things will be done by the collectors of that particular place. This is the overall discussion about the land laws, the first unit, that is right to fair compensation according to Right to Fair Compensation Act 2013.